Okay. Ellarigu namaskara. Welcome to the online seminar being conducted by the Karnataka State Bar Council and its Law Academy. And today's topic is the economically weaker section reservation, which is recently decided by the Constitution Bench of the Honorable Supreme Court of India in the matter of Janhit Abhiyan versus Union of India, writ petition number 55 of 2019, decided on 7th November 2022. Now, 4 judgments were rendered by Justice Dinesh Maheshwari, Justice S. Ravindra Bhatt for himself and on behalf of Honorable the Chief Justice, Justice Bela M. Trivedi, and Justice J.B. Padiwala. The questions which were framed by Justice Dinesh Maheshwari are as follows, so that you can understand, the others can understand the entire gamut of it. Question number 1 was as to whether reservation is an instrument for inclusion of socially and educationally backward classes to mainstream of society, and therefore reservation structured singularly on economic criteria violates the basic structure of the Constitution of India. Now, the answer given by Justice Dinesh Maheshwari, which is a majority judgment supported by Justice Bela Trivedi and Justice Padiwala, is that a reservation is an instrument of affirmative action by the state so as to ensure all-inclusive march towards the goals of an egalitarian society while countering inequalities. It is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for inclusion of any class or section so disadvantaged as to be answering the description of a weaker section. In this background, reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structures of the Constitution of India. Now, the question B, whether the exclusion of classes covered under Article 15.4, 15.5, and 16.4 from getting benefit of reservation as economically weaker sections violates the equality code and thereby the basic structure doctrine. The answer is that the exclusion of classes covered by Article 15.4, 15.5, and 16.4 from getting the benefit of reservation as economically weaker sections, being in the nature of a balancing requirement of non-discrimination and compensatory discrimination, does not violate equality code and does not in any manner cause damage to the basic structure of the Constitution of India. Question C, that's the last question, just whether reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations results in violation of basic structure on account of breaching the ceiling limit of 50%. The answer is reservation for economically weaker sections of citizens up to 10% in addition to the existing reservation does not result in violation of any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India on account of breach of the ceiling limit of the 50%, because the ceiling limit itself is not inflexible and any case applies only to the reservation envisaged under 15.4, 15.5, and 16.4 of the Constitution of India. Now, the conclusions are here. That is, 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation based on economic criteria. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to admission to private unaided institutions. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by excluding SEBs, OBC, SC, ST from the scope of EWS reservation. Now we have with us very distinguished panelists. The information about them is already given to you. We have Mr. S.P. Shankar, Senior Advocate, Bangalore, Gulbarga, Dharwad, and the Honorable Supreme Court of India. Mr. Mohan Katarki, Senior Advocate, Supreme Court of India. Mr. Sridhar Prabhu, Senior Lawyer, High Court of Karnataka. Mr. Nikhil Mehra, Senior Lawyer, Supreme Court of India. Mr. Aditya Sanghi, Senior Lawyer, Supreme Court of India. So, without wasting much time, I request Mr. Advocate S.P. Shankar, Senior Advocate, to lead the discussion on the topic. Mr. Shankar, sir. Gautam, kind 1 minute.
Yeah, I must notice and acknowledge the intimidating presence of Mr. Mohan Katarki, Mr. Prabhu Mehra, and Siddharth Sajaria. Well, on noticing this, I ventured to add a few submissions, as it were, to this learned panel. This issue of basic structure, breach of basic structure, appears in all the three questions, and question A and C are answered in a particular fashion. Exclusion is the primary object in the matter of attaining equality. Exclude some and concentrate on the others is perhaps the issue. Before that, I think we should go to the history of this situation. In the year 1936, reservation was provided in favor of depressed classes. I don't know why they used the word depressed classes, but that was the situation. And perhaps they thought that A section was depressed and kept out of all the benefits. Therefore, they must be free. This was done by the British government. This continued. That was in the year 1936. 12 years later, we had our own wave mechanism and we started doing it. Then the two decisions which mark the beginning of the struggle for reservation or for the representation appeared through two decisions, Champakam Dora Raj and Balaji, M.R. Balaji. This led to amendment in a way to protect their interests, and thereafterwards there have been successive amendments to take us to the present situation. 103rd Amendment is perhaps not the last of the protections afforded. This takes us to the basic issue as to whether this protection given is a favor or is a compulsion. We'll have to set apart two concepts to reconcile this situation, namely fundamental rights, which provides equality, which assures equality, and the directive principles of the state policy. Article 46 specially mandates that interest of the weaker sections must be protected and they must be promoted. This is the assurance given, and state policy, though it is not enforceable, has as much a force as fundamental rights themselves are. Now, fundamental rights are now as in the nascent form of Article 14, 15, and 16, we did not visualize that there would be difficulty in extending the protection to the much deserved persons, namely persons who were neglected throughout hundreds of years. So the amendment was not merely a helpful hand extended to the backward classes or backward sections, but it was necessarily, it was a compulsive situation for the Union of India or the states to provide some sort of help to these sections of the society. And with that, they started providing the 10-day, all of us will remember, Tamil Nadu extended the reservation to a larger extent of more than 68, and ultimately this issue was decided in Indira Sahani, and Indira Sahani has made excellent benchmark for the purpose of promoting the interest of this neglected section. Thereafter, the executive provided for reservation, and challenge made to this was always not appreciated by the authorities, and they have come down heavily on the state governments, which did not live up to the expectation, and they struck down one after the other. And the situation is this now. We will have to first start with the concept, namely these sections who were neglected in the society were not extended the benefit, and some provisions had to be made. the other aspect is reservation a fundamental right? Is it an enforceable right? Both the directive principles and this 15 and 16 will assure that it's the discretion of the state to extend this benefit. If the moment they use the word discretion, enforceability is taken away. The first decision we'll have to note this is 1968 Supreme Court 507, Nagaraj versus in this Nagaraj's case. There, the observation of the Supreme Court is no constitutional duty is imposed on the government under Article 16 of the Constitution that there should be equality of opportunity for all citizens in the matters related to employment or appointment to any office under the state. Our promotion from one office to another office. Article 14 and 15 form part of the same constitutional code and guarantees and supplement each other. It follows, therefore, that there can be reasonable classification of the employees for the purpose of appointment and promotion. This is where we started analyzing the issue. No constitutional duty is imposed on government. That means there's no fundamental right for purpose of reservation. This is the first decision to say that there's no fundamental right for reservation. And this decision again says it's a matter of discretion for the state to do it. So if we start analyzing things from this perspective, namely, it's a directive principle or a state policy to provide reservation, and therefore it is perhaps not enforceable, but it is it has to be synthesized with Articles 14, 15, 16 on one hand, 21 read with 21, then this directive principles. We can comfortably say that there has to be a balance of these things, which is the prime dona for Indira Sahani. In Indira Sahani, they said harmonizing the fundamental rights and with the directive principles is essential for the purpose of delivering this promise of the Constitution, namely to the weaker sections. Now, all along, we have seen that the tilt in favor of the neglected sections of the society, it was appreciated by all concerned, and it continued for long. Now, the ultimate issue came up for consideration in Vasant Kumar was the state of Karnataka. All of us will remember, for the first time, the economic consideration, economic criteria was one of the aspects that we looked into. Is the law declared in Vasant Kumar? The present situation, namely questions A and C, do not arise for the first time in the nation. It had arisen in Vasant Kumar. It had been answered. So what is now answered is kindly see question A and question C and are the answers given. Is there total exclusion of the other considerations, and is there primacy according to the economic weakness? No. Therefore, question A assumes that economic weakness alone is taken as the criterion for this. No, perhaps if one reads the question again and the answer also looks at the answer given, we come to the conclusion that the question is not worded properly, or perhaps you can say that the question begs itself. The situation is A and C, both of them are addressed to the same problem, namely whether reservation in favor of on the criteria of economic issues is valid or not. The answer is given saying that yes, it's also one of the factors. I have one small the similarity to be addressed on this issue. Well, it is required both in terms of the fundamental rights as well as the directive principles that the reservation has to be provided to this. Mr. Prabhu sir, I am requesting your attention to this issue, where the insistence is that we have got to accommodate the members of the weaker section, and from 1950 up till now, we have provided that accommodation. The reasonable thinking, perhaps it's not a premise on which I'm resting my further narration, is a reasonable assumption could be made from this situation, namely, before an aircraft takes off, it taxis around. Taxiing around is a protected thing that it is not in the air, but it's on the ground, and all assistance is given to that aircraft to take off. The takeoff is liberation from the backwardness and reaching the enlightenment. If an aircraft is allowed to taxi around all the time without reaching Dharwad or Hubli or Gulbarga, it's no use. So therefore, at one point of time, taxing must stop and taking off must start. That is the primary intention of the Constitution, and not eternal protection given to any person. This has to be done in even this economic criterion also. It's not for all times to come. One has to fend for himself. One has to guard his own interests. In this situation, this perpetuation of this class has some good reason behind it. Namely, the Constitution could have provided for 10 years and nothing more. Constitution did not say it. Constitution has also not been amended to say that we have crossed 70 years and 7 times that extension is given. Stop it. No. The people of India who have given themselves this Constitution, also the power to amend the Constitution, do say that this protection of 10 years will be continued as long as we want. Taxing continues as long as they cannot take off. That means they are interlinked. Taxing is linked with the power to take off. If the unfortunate brothers and sisters of our society are not in a position to take off on their own, their protection must be continued to be given, is the essential premise on which we have to start our discussion today. There is no over protection or enthusiastic the extension of the umbrella to any section, but also not to neglect the other sections. There has to be balance between the two. In this situation, the present decision has indicated some nuances. I am inviting the attention to paragraph 27 of the judgment of Justice Maheshwari. Kindly see, there is a reference made to Dr. Jayashree Patil and Nagaraj. And what is canvassed is, he has further submitted that as held by Jayashree Patil, there must be harmony between the fundamental rights and directive principles as well as state policy, which the amendment seeks to strike. Further, the London Council would submit that the challenge in Indira Sahani was to an office memorandum, and the view of the court that the economic criteria cannot be sole basis ran contrary to its own view, excluding creamy layers overseas. So this takes us to the second aspect of the effects of reservation. The reservation intended to cover and benefit the whole lot of the backward classes, while in implementation we have found that that has not met with success, and instead of reaching the entire the intended population of backward community or backward classes, it is concentrating in the hands of A, B, C, D from that section. The state has a responsibility to see that there is no concentration of wealth on account of this situation, and this creamy layer should not be benefited from this. Indira Sahani has said this, and that has not seen any assistance from either the further hearings of the court or further considerations of the court, or even from the parliament. We have got to pay attention to this in the course of this discussion itself, is my view. Then we have to pay attention to the paragraph 57 of the at page 95 of this downloaded copy. After having traversed through the two fundamental aspects, equality and reservation, we may focus on the central point of consideration in these matters, the economic disabilities and affirmative action in that regard. Enough background is created for the purpose of taking affirmative action even on economic disabilities. Starting from Keshavananda, it proceeds to cover several judgments, especially Nath Shukla and Minerva Mills, Ahmedabad Municipal Corporation, and perhaps this People's Union for Public Committees. There, the social obligation, the economic and cultural rights of the Indian population are considered, and an issue is made out for saying that economic disability is also a criteria must be taken into consideration. The next aspect is whether economic criteria as a sole basis for affirmative action, paragraph 68. This really discusses the present troubling issue, whether economic criteria is the sole, can be the sole basis for affirmative, and it is answered in question A as well as in question C. Now, the next thing to be noticed is Krishnayer's observations in the earlier decision, Thomas versus Kerala State Board, paragraph 120, where Justice Krishnayer may I use the word, dominated himself in expressing the view and both on the fundamental rights and the directive principles. This requires consideration by us at least. Then we have all these narrations which I read to you are from Justice Maheshwari's judgment. Then we have to Justice Ravindra versus opinion. Kindly go to paragraph 2, where the submissions are noticed. At the outset, I must state that I am in agreement with the addition or the insertion of the economic criteria for affirmative action in aid of the action section of the population who face deprivation due to poverty in furtherance of Article 46 does not per se stray from the constitutional principles so as to alter, violate, or destroy its basic structure, as long as the state addresses deprivation resulting from discriminatory social practices which have kept largest number of our population in the margins and continues to do ameliorative policies. This is exactly what we have also tried to impress on the nation now. Then kindly see, this Justice Ravindra Bhatt has referred to the context and history of reservation. Then he has dealt with the various provisions of the case and the doctrine of they've set out in paragraph 4. And he would ultimately say that this excessive the protection given to the economically weaker sections do not deserve consideration, do not deserve merit, and he concludes that it's not necessary to extend this commission. I think by and large, this judgment would ultimately, its merit depends on the answer to the questions A and C, and these answers are also on the narrow margin. Economic disability is not confined to any particular area or a particular say, the population of the region of that region. We will have to see that to be poor is not sin, and poverty is never a crime. Though poverty may arise out of crime, as what people would say. In this situation, we will have to discuss whether the present judgment is to be accepted as a final one, or in view of the split of ratio of 3:2, whether there is further scope. There is already the opinion running around that the application for review is being filed, and the reconsideration of large judgments, all this is filed. I think the enlightened panelists would deal with this situation in the manner that the Bar Council of Karnataka would desire you to help us to flow through and make further progress. I am grateful to you for this opportunity.
We'll come back to you, sir. We'll come back to you during this session itself. Mr. Mohan Katarki, sir, Senior Advocate, Supreme Court of India.
Basaraj, can you hear me?
Yes, sir. Yes, sir.
Yeah. May I at the outset thank Karnataka State Bar Council and particularly Basaraj for extending this invitation to speak on the occasion. After Sri Shankar has spoken, there is really nothing for me to speak on the judgment as such. He has thoroughly analyzed the contents of the judgment, the conclusions of the judges, and the questions which arose for consideration. If we go back to the theory, why the reservation became necessary in this country, there is a very interesting background. Although we have all explored it from the point that it started as a reservation against the Brahmin domination in India. But I found somewhere, I'm not immediately able to locate it, the first persons to seek reservation in India were the sons of the British officials who served in India, who fought various wars against Indians. And those sons said, we have contributed a lot to the acquisition of India for the crown. Therefore, in the selection of Indian civil service and the Indian police, there should be reservation against the British who straight come from England. So this is how the a reservation history arose in India. Thereafter, sometime in 1870, there is a record that the leading barrister of Calcutta, Lalit Mohan Ghosh, traveled to London in those days by ship to address members of the parliament seeking reservation in favor of Indians in the Indian civil service. But both of these were not successful. Neither the sons of the English officers who served in India got a reservation against the Englishmen coming from England, or the Indians got the reservation in the Indian civil service. But later, as we all know, that first reservation came in Madras presidency, where some sort of a reservation was given to the backward classes. And thereafter, the princely states, particularly Mysore, Kolhapur, and Baroda, were able to implement it in a more aggressive manner. And finally, in 1936, the government of India then took a decision to create a reservation in favor of depressed classes, who are roughly now equated to the scheduled caste and scheduled tribe. This is how the history of reservation. Then finally, in the Constitution of India in 1950, we have adopted it in a more nuanced manner, providing for reservation not only to the scheduled caste and scheduled tribe, but also to the other backward classes. And a lot of controversy has arisen with regard to that. Now, after 70 years, one more category of reservation has been created, that is economically weaker section of the people. So this has created a lot of political debate, though all political parties except few are unanimous that there has to be a reservation for the economically weaker section of people. The main grievance of those who have been challenging this reservation comes not from the forward community. That means those who are not poor in the forward community, they are not aggrieved that why 10% reservation is given out of the quota of the forward caste or the general category. But the challenge has come from the backward class, scheduled caste and scheduled tribe on a ground that the reservation is a special thing under the Constitution as an affirmative action, which privilege only can be extended to those who are socially and educationally backward and Dalits. It cannot be given on the ground of economic consideration. Many asked the question, including I also asked, what is your grievance? Why do you say that reservation is only your privilege? Do you have the monopoly of reservation that it should be only given to you? If another category is created, what's your problem? Nobody was able to satisfactorily answer. In fact, one of the judge also has noted this. But the fear seems to be this, which has some substance, that if economic consideration is the basis of reservation, in future, the reservation, the entire gamut of reservation might be based upon the economic consideration. As a result, the social backwardness, which is the main criteria for identifying and uplifting the backward classes, may disappear. That is the fear is there. Whether that is right or not is a different question, but that seems to be the fear that in the course of time, ultimately, the social backwardness, which is the correct criteria for identifying who is backward in this country, will disappear. It will only become a economic backwardness or economically disadvantaged class, or economic criteria will be adopted. So that might really cost them a lot. That is the fear, whatever it is. Now, coming to the judgment, as a lawyer, we are more concerned with the legal analysis of the subject than a political analysis or a political reasons behind the amendment to the Constitution, that is 103rd Amendment. The judgment by 5 judges, the split verdict, majority is by 3, led by Justice Maheshwari, and minority judgment is written by Justice Ravindra Bhatt, supported by the Chief Justice. Chief Justice of India should have been leading the bench, but maybe because of the paucity of time and he was retiring, he allowed it others to write, and he has agreed with Justice Bhatt and he's in the minority. Now the question is, you all read it, know the conclusions, that 3 judges have upheld the constitutional amendment providing reservation on the ground of economic weakness or economic criteria. First question that arises for consideration is, whether the judgment is per incurium or there is nothing. This is final. And let us proceed from hereafter. To my mind, the per incurium could be a ground for review of a judgment under Article 137 of the Constitution, if you are able to show that some important consideration or some important legal issue was ignored by the judges while writing a judgment. The important point which falls for consideration on the ground of per incurium is Justice Bhatt himself has answered, in fact, after reading the majority judgment, that the test for basic structure applied by the majority is erroneous. Majority judgment of 3, that is Maheshwari, has relied upon the test of unconscionability enunciated by Justice Krishna Iyer in Maharao Bhimji case. But Justice Ravindra Bhatt, in his dissent, has dealt with the Bhimji case at para 148 or page 84 of his judgment, if I'm right, yeah, page 84. And he very correctly says that the test is not the unconscionability. The correct test is as laid in the Nagaraj case, that is whether the identity of the Constitution will be damaged, destroyed. That is the test. Unfortunately, though Nagaraj case was argued, and it is noted by Justice Maheshwari in his judgment at a couple of pages, but when it comes to the analysis by Justice Maheshwari, he has not dealt with the Nagaraj case at all. That's what I could see. So this could be an error which is apparent because the real test is Nagaraj case. The Nagaraj case provides a very authoritative test for identifying what are the basic features of the Constitution. Justice Kapadia went through the whole thing, the entire case law after analysis, came to the conclusion that the basic structure is not represented by any particular article of the Constitution. It is a feature or a principle which relates to the identity of the Constitution. There are many principles in the Constitution, not only one principle, because the Constitution is built upon several principles. Maybe the first principle is the rule of law. Then there is a principle of federalism. There are several principles of there, equality, freedoms, so many things. But the most important thing, according to Kapadia, is that the principle which is sought to be altered by the parliament, by constitutional amendment, should lead to the destruction of the identity of the Constitution. If the identity is destroyed or threatened identity, then basic structure is affected. That is the test. Now, whether in this case it is affected or not is a different matter. But somehow, Justice Maheshwari has not applied this test. He has gone on a different test. That is, if I can read in his judgment at page 84. Yeah. Mere violation of the rule of equality does not violate the basic structure of the Constitution unless violation is shocking, unconscionable, and unscrupulous travesty of the quintessence of the equal justice as exposited in Bhim Singh case. So, in fact, Maheshwari has also not dealt with what is this Bhim Singh case. Of course, he has referred to this case while noting the arguments of Attorney General at a couple of pages in his judgment. But when he takes up the analysis, I couldn't see him dealing with Bhimji case, but straightway he has come to the conclusion that this test applies. Okay, it happens sometimes. I'm not doing it. But did Bhimji lay down any test? No. because Krishna Iyer, who wrote a concurring opinion in Bhimji case, has alone stated this. Other 4 judges have not said anything on this, and this has not been the test applied in Nagaraj case, which judgment is considered to be an authority on the point of basic structure. Therefore, this is one ground I feel the judgment is per inquirium and may require a reconsideration, because it's not just application of a wrong principle of basic structure. Consequently, what happens is Justice Ravindra Bhatt, based upon this, has gone ahead and said that if we exclude socially and educationally backward class of people, SCBC, from the purview of economically weaker section, which is the section coming from Article 46, which has been now a basis for the reservation, that will create a discrimination, unjustified discrimination. Exclusionary clause is not justified, and therefore equality clause is violated, right? And he said this equality clause, in this essence, is the identity of the Constitution, because the entire Constitution of India, which stands on the rule of law, and the rule of law stands on 2 things. One is protection of the freedom, second is protection of the equality. So the identity of the Constitution is affected if the identity test is applied and if this protection of the SCBC is a part of it. So this is how he has gone, and therefore I feel on this ground there are good chances of the judgment being reviewed and referred to larger bench for consideration. Then the second question which arises for consideration and which has been very widely debated in the public is whether the judgment will have any impact on the Indira Sahani case. Because we all know, and it has been very widely debated, and it is a very controversial issue also. There are 2 sides to the story in India, that whether reservation should be based upon the caste or not. While laying down the test for identification of the socially and economically backward class of people under Article 15.4 and 16.4, the Supreme Court has applied caste as a test. Not that a caste by itself becomes, but they have taken caste as a unit for the purpose of assessment whether it is socially, educationally, economically backward or not. So this has come to be known as a caste-based reservation in India. It's not exactly correct, but this is how it is being said so. So the question is, if 5 judges of the Supreme Court, majority as well as the minority, have concurred that economic consideration can be a sole consideration for the purpose of reservation, will it have an impact on the judgments rendered under Article 15 and 16 of the Constitution? That is the point. But if you look to the judgment of Justice Maheshwari, he himself has clarified that the test applied in Article 15.4, 15.5 and 16.4 cannot be the test to be applied for deciding a reservation under 15.6 and 16.6 now introduced by constitutional amendment, because he makes a classification very clearly that economically weaker section is entirely different class of people, whereas the socially, educationally backward class of people protected under Article 15.4 and 16.4 are separate. Therefore, those tests do not apply here. As a consequence, I would say these tests will also do not apply to that. Therefore, it is very unlikely that this case would have any impact upon the Indira Sahani case, and there is going to be any ground for reconsideration of Indira Sahani case solely based upon a fact that economic consideration has been accepted as a criteria, a sole criteria for reservation in Janith case. If I can read para 73 of Justice Maheshwari judgment, this will dispel all the doubts. In view of the principle discernible from the decisions aforesaid, as also the background aspects, including the overt objects of economic justice in the Constitution, the observation of the court in the past decisions that reservations cannot be claimed only on the economic criteria apply only to class or classes covered by or seeking coverage under Article 15.4 and or 15.5 and or 16.4 and else. This court has not put a blanket ban on providing reservation for other sections who are disadvantaged due to the economic conditions. Fine. Therefore, while dealing with the cases where economic consideration is not a sole criteria being considered by Indra Sani and all, court has said those cases deal with Article 15.4, 16.4 and 15.5 and they do not apply. Therefore, if they do not apply, this case will not apply for the reconsideration of that case also. Therefore, we have now two compartments of reservation, which Attorney General put it in the court very nicely, that one is backward class and Dalits, and the second compartment is the EWS quota. Therefore, the test applied in EWS cannot be applied to the socially economically backward class, and the test applied for social economic cannot apply to the EWS quota. Therefore, the fear of some people that ultimately the economic consideration will come and destroy the reservation system based upon the socially educationally backwardness is not true. I don't think it's going to happen. Therefore, with these two observations, I would like to close my brief talk. I thank Mr. Basaraj and all for this patient hearing and giving an opportunity for me to spell out in a short time span of time. We're all busy with our own professions. To scan the judgment of 400 pages is not easy. And there are many strokes, as I had written it on the social media. When it comes to the judgment of Mr. Maheshwari, it is a sixer. It can just straightway read it. But Justice Bhatt's judgment has many aspects, very well analyzed, very thoughtfully written judgment. Not because I like the conclusion, but as we go through, we feel it. So it takes time. But these are the broad aspects, two questions, which I thought I should address, particularly the second question, whether it will have any impact on the Indra Sahni case. According to me, it will have no impact because these criteria are different, those criteria are different. Both cannot be mixed together. Now, two are on two different streams altogether. Thank you very much.
Yes, thanks, sir. Mr. Nikhil Mehra, Advocate, Supreme Court of India.
Thank you, Mr. Basaraju. First of all, I'd like to thank the KSBC for inviting me. I'm probably the only lawyer on this panel who doesn't otherwise have a link to Karnataka. So it's very kind of you to have considered me as well. Although I did have the privilege and the pleasure of studying my 5 years of law school at Bangalore, which is one of the best cities in this country by far. I would, much of the judgment has already been analyzed in terms of its content. I would like to now move specifically to my comments on what I feel has been the driving force and what are the derivative principles that emerge from this government, from this judgment. First and foremost, as lawyers, we have a tendency of reducing or wanting to see absolutely everything in conceptual terms. And a concept consists of its own rigidities. We are not comfortable, or we make the assumption that the political sphere is the uneasy sphere or is the unsettled sphere where things will not remain as they ought to be. Whereas the truth is that the judgment makes it absolutely clear that while a concept of reservation exists within 15.4, 16.4, or 15 and 16 in general, even if you add in 5 and now 6 each, 15.6 and 16.6 each, the manner in which this reservation will occur, the manner in which this upliftment of equality will occur is actually entirely within the political sphere. And so therefore, it is entirely a matter of policy. And so as SPS sir said right at the start, there is no obligation to reservation. You can actually imagine a set of exams set up by a state government that says 0 reservation, but the political reality will not permit it. And that is a much better thing in my view for what we are attempting to achieve here than to have a constitutional constitutional Grundnorm established. And so to that end, when I read the judgment, I see a unanimity, and this is an important point. It is indisputable that on one of the main issues that was raised, the judgment is a 3-2 majority. That issue is only on the breach of the 50% quota as set up by Indira Sahni. But on the first and principal point of challenge that was raised by Professor Mohan Gopal on behalf of the petitioners, that the economic criteria cannot be a basis for reservation at all, there is unanimity by the court. And that is all 5 judges accept that economic criteria can be the basis of reservation per se. And this is an important distinction to draw, because what is happening in real terms, I mean, it is all right to discuss this in theoretical terms, but in real terms, you are adding on another layer of vertical reservation. And vertical versus horizontal, for those who are listening, who are not comfortable or are not aware of these concepts, vertical reservation is what eats into the 100% quota that is the 100% totality that exists. So if you have, say, 27% for SCST, 10% for OBC, and another 10% for someone else, the others, you have 47% in the vertical slab. You may then have reservations, for example, for women, which are 15%. These will apply across all of these prior vertical reservations. So it will be 15% in SCST for women, 15% in OBC for women, 15% in any other basis that has been achieved. When you therefore create a fresh vertical reservation, as Mr. Ketarki has clarified in his prior comments, you have created a completely separate class of reservation. And this creation of a separate class of reservation is what guided the court in upholding the fact that you have now, by creating a separate class, all we have to examine is whether the creation of this separate class is violative of the basic structure. If it is not violative of the basic structure, the fact that it is exclusionary to the prior beneficiaries under the 15.4 and 16.4 and 15.5, 16.5 reservations is of no materiality whatsoever, because the creation of a separate class inherently means that someone is being excluded. That is exactly the purpose of a vertical reservation. So, as I said right at the start, the idea that the courts accept now, and all 5 accept, is the basis of reservation, the nature of reservation is a holistic requirement of equality per se, and it is the political sphere, the policy-making sphere, which best understands how to address this. And it is a hard-fought battle to say that the political sphere eventually moves to the legal sphere, which is a law is passed, and an even harder battle to say that law, instead of a law being passed, we are going to pass a constitutional amendment. And this amendment passes without virtually any demurrer in either House of Parliament. Let's be crystal clear about that as well. So, as to the legitimacy of the taxonomy set up by the amendment, there is unanimity. That's step 1. Step 2 is whether the 50% requirement was an inviolable requirement, or whether 50% was only in a certain sense a directory requirement. Indira Sahni in itself, right from the inception, it said 50% is the norm to be followed. There are a multitude of judgments from Indira Sahni downwards which re-established a 50% norm, but not one single judgment said it is mandatory. And the reason it could not say it is mandatory is that there is no constitutional basis for saying it is mandatory. You do not have any provision of law that says it must be mandatory. 50% or otherwise is done basis of some basic understanding of how this entire process should proceed, a balancing of rights. You have to look at those who do not get reservations. So you're balancing their Article 21 rights. You're balancing possibly the Article 19(1)(g) rights. And so therefore you arrive at this 50% norm. But even Indira Sahni says in exceptional circumstances you can cross. They found this exceptional circumstance in this category of reservation, which is the economically weaker sections. So one of the criticisms I have of the judgment is at no point in this judgment did I see any data. None of these judgments contain actual data of who is EWS, what is the mobility between EWS, and this was necessary because the petitioners, in my view, raised an excellent argument, which was that EWS, by its definition, by its nature, is an individual inability and not a class-based inability. 15.4, 15.5, 15.6, 16.4, 16.5, 16.6, and that entire setup, in that entire code, the equality code, applies to class-based backwardness and not to individual-based backwardness. And so this argument wasn't, in my view, thoroughly met and could only have been met by use of data. One of the counsel I read had made the argument that actually this EWS, what would comprise EWS, once you exclude the economically weaker sections belonging to those who already get reservation under 15.4 and 16.4, would only be about 5 to 7% of the population, and yet the quota is permitted up to 10%. And so, therefore, it is facially unreasonable, and unreasonable in a way that would violate the basic structure. That argument doesn't find any kind of statistical dealing with. And really, when you are, what therefore happens then is that once you are unable to posit that 15.4, 16.4, 15.5, 16.5 actually embody fundamental rights, positive fundamental rights, there is no strict scrutiny applied for 15.6 and 16.6, right? So 15.6 and 16.6 only need to pass muster conceptually. And conceptually, all they required to pass muster was to say, really speaking, in our entire reservational structure from the 40s downwards, particularly even through Indira Sahni, the question of what is the correct kind of reservation, how it is to be tailored, how it is to be applied, is really a matter of the political sphere and of policy making. And for this reason, for these last 3 decades since Indira Sahni, we have accepted economically weaker criteria in the context of housing. We've accepted it in the context of land. We've accepted it in education. We've accepted it in various other forms of employment, right? One of the criticisms I have of the petitioner's approach to this case was they had an excellent argument that I think originates to the heart of the constitutional mandate on reservations in public employment, and particularly employment under the state, which is that those who have never for centuries and millennia had the power to rule must also have a power sharing and must have the right to rule and decide their own future within a democracy. And so therefore, if today you are to say, so you would then be distinguishing reservation in the context of public employment, particularly employment under the state, particularly relating to bureaucratic appointments, appointments within the IS and appointments within the permanent government, as we call it, versus, say, reservations in educational institutions in and other criteria. The reason I say this is because economic inviolability of a person or the economic weakness of a person may directly relate to their inability to procure and obtain the best possible education. But the issue of whether or not that then pertains to their inability to be part of the governance structure, there that becomes a question of the class they belong to. And it is a set of classes that were removed from government for millennia altogether. And in their case, the argument is stronger. And this argument is also raised by the petitioners. And I do not actually see any kind of response to it in any of the judgments. The specific argument raised was that there have been people who have for millennia been shut out altogether from governance, from power, from rulemaking. Now, to the extent of rulemaking, we have remedied that, corrected that, because Article 342 onwards, we have various reservations in relation to SC, STs, and OBCs in Parliament, in other lower and local rule-making bodies. But an argument pertaining specifically to, say, the IS exam, say to state administrative services exam, would have qualitatively, in my view, been slightly different from a challenge pertaining, an omnibus challenge that speaks of educational institutions as well. Qualitatively, it is somewhat different. And again, I don't see, while that argument was made, it is noticed by Justice Maheshwari, I don't see that argument actually being properly dealt with. So these are certain gaps that I see in the judgment. But on that larger concept, I'd like to say that when we come to the basis of the diversion in the judgment, which is the 50% criterion, let's put aside for a moment who got the analysis right and who did not get the analysis right. But let's look at the fact that this is one of those sliding doors moments, I think, in Indian constitutional law, where perhaps those who think they have won today will eventually realize they may have lost. And those who think they have lost today may eventually realize they have won. The inviolability of the 50% criteria was an essential protection that certain persons who espouse the cause of removal of reservations, for example, they had this particular protection to ensure that merit remained, as they call it, merit remained a crucial defining factor of all appointments and of all admissions. Today, when 50% becomes violable, there is really nothing I see in this judgment that says violable only for this purpose and this reason only, and not violable for another reason. Although all of these judgments today, even today, the majority judgments say the 50% rule we're allowing you to breach because it applied only to 15.4 and 16.4. But I do not see a conceptual basis for, you have dislodged the concept of 50% per se. So tomorrow I don't see why you cannot turn around and say 15.4 and 16.4 also, you can go beyond 50%. As we speak, today I've just seen one PTI press release that state of Jharkhand has come up with a reservation law which will amount to 77% reservation. Now we don't know what all this includes, what it doesn't include. So there is one set of people who feel that this judgment is scary because it takes away the primary criteria of reservation, which was backwardness, which was the caste system, but and extends benefits to those who have always been rulers as well. And eventually, the aim of who pronounce judgment is that you will remove reservations altogether, and you will then stop, and then you will undo this entire process of the reparations that have to be effected because of the caste system. But that is one fear. And that is why I call it that is one direction they feel this judgment would go in. The other fear is that no, in fact, now when 50% is now violated and is permitted to be violated, you are not too far away potentially from proportionate quotas, where a state could potentially pass a law on proportionate quotas, back it up with data, show that the data pertains to specific castes, specific economic weaknesses, and create that proportionate system. How that will play out in the context of 19(1)(g), 21 on the issue of merit could very easily be redefined. We now have a Chief Justice who, in fact, already in his judgments been redefining merit. And he looks at sort of a very broad definition of what constitutes merit. So therefore, I look at this particular principle of 50% being permitted to go as a sliding doors moment, because we could end up with a direction of politics that says, look, eventually we have to look at caste-based reservations going away. This seems to be what has motivated Justice Bela Trivedi, Justice Pardiwala. And you could have the other direction which says, well, 50% is now violated. That means we can have any kind of reservation as long as the state can come and show this was necessary, it was essential for equality, for the purpose of equality. And this is what disturbs Justice Bhatt. Because Justice Bhatt, therefore, says 50% you should not have crossed. It's a very important requirement. He, of course, does not eventually answer the question of the inviolability of 50% because he does not require to. He strikes down the legislation already by the very fact that there is exclusion of SC, ST, and OBC or SEBC poor from the 10% quota. Having struck the amendment down on that count, he does not go further with the 50% issue, but he makes an observation on that issue, saying that if you are going to go this far and you start breaching 50%, you may be in a situation where merit will no longer have a say whatsoever. Right? So it is one thing to look at in the context of this judgment. It is one thing to look at the concepts that we sort of examine, and as lawyers we are bound and beholden to concepts. So we'll have to first accept that the concept that is in fact established here is that the politics is above a ground norm, and that the politics will decide first. And The politics, of course, can now go in either direction. And as I pointed out, you could have a sliding doors moment. You could have more and more reservation, or you could end up with reservations that sort of remove away. In a larger sense, and if we want to be more precise about what the problem at hand is, what we have is a major supply side problem. We simply do not have enough educational institutions. We simply don't make it easy to establish educational institutions. We have some certain very archaic principles that, for example, say education can never be a business. So therefore, your pricing is governed by the state. Your fee structure is governed by the state. At times, management is governed by the state, and we create arbitrage even in that because minority institutions are excluded from that same situation. Is there a problem? Just concluding. Now, so just in conclusion, because I've been prompted by Basavaraja sir, I'd like to point out that this sliding door moment, what I've described, is the most important thing to observe going forward in terms of how both politics as well as the law on this issue carries forward. Thank you.
Thank you very much. There are three more speakers. That's why. Mr. Sridhar Prabhu, Senior Lawyer, High Court of Karnataka, kindly enlighten us.
Yes, sir. Thank you so much, sir. Now, I will be very pointed and straight in my submissions. Well, the major argument, the political argument as well as the legal argument against this judgment seems to be that it excludes the scheduled castes, scheduled tribes, and the OBCs from the ambit of the EWS quota. Now, this is the heart of the matter, because as my previous speaker, very rightly, Mr. Mehra, very rightly pointed out, there was just a word of caution by Honorable Justice Ravindra Bhatt, but the legislation was not struck down by the minority on the ground that it exceeds the 50% quota laid down by various judgments, including Indra Sahni. Now, this is the heart of the matter. So therefore, I'll come straight to the point. In fact, the reservation to the SC/STs has never been on the economic criterion at all. So therefore, to say that they should have been included, the poorest among the SC/STs should be included in the EWS, is a completely faulted logic, because SC/STs form a class in themselves, and economic criterion has never been the basis. Even if you are a billionaire and belong to a scheduled caste or scheduled tribe, you still are entitled to the SC/ST reservation. There is no creamy layer concept at all in the SC/ST reservation, and therefore the non-inclusion of SC/STs into the EWS quota is perfectly a justifiable criterion. So when you don't apply the economic criterion for the SC/STs, when you don't create a subsection within SC/STs by saying, let us target the most poorest among the poorest among the SC/STs and exclude, let us apply creamy layer to the SC/STs and exclude the richer class within it, you do not have a right to say that such section should get into the EWS quota and get a reservation in the EWS section at all. Honorable Justice P.B. Sawant's judgment in Indra Sahni very clearly says, as far as the SC/STs are concerned, it is the political empowerment that is at the heart of the matter. See, because the SC/STs also get political reservation, the OBCs do not get. The SC/STs do get a political reservation. So the entire idea or rationale behind the SC/ST reservation has been the social empowerment and not the economic empowerment at all. So therefore, not including the SC/STs is a perfectly logical decision by the legislature, and Honorable Justice Dinesh Maheshwari's judgment very clearly analyzes this and says, when you create a category such as EWS, such as SC, such as ST, such as OBC, you clearly create a discrimination by default or without purpose. But there is a vertical schism, vertical compartmentalization that you create and it is inviolable. Suppose you say, if this logic given by the minority view is extended, let me tell you how dangerous proportions it can assume. Now, for instance, if you say, look, there is a SC candidate who is not able to get an admission to a educational institution because the SC quota is full, but OBC quota is open. So why not allow a SC candidate to get into the OBC quota? Because he is also backward, most backward, and also he has the stigma of untouchability. He's the backward among the backward, most socially backward, educationally backward community. So why not he be allowed into the OBC quota? Why should he not transmigrate into some other quota and somehow get into the educational institution? Because he is the most deprived of the deprived. So when you don't allow the SC/STs to get into the OBC quota, what right have you got to say that he should be allowed in the EWS quota, or the vice versa? So therefore, these are vertical compartmentalizations, and these are not horizontal reservations, these are vertical reservations. So therefore, there is a clear-cut demarcation between the SC/STs and the EWS. This is one. Secondly, when it comes to the OBC reservation, there is creamy layer applied. And this creamy layer criterion is very much akin to the EWS economic criterion that the legislature applies. So very similar. And the rich among the OBCs are already excluded, and those who are getting reservation in the OBC quota are only the poor. Now, are you then saying that the poor among the OBCs are getting reservation already, but then they should be allowed in some other quota as well? If you extend this logic, then you are defeating the compartmentalization of vertical reservation logic entirely. So therefore, non-inclusion of SC/STs and the OBCs into the EWS quota is perfectly justified. And those who are arguing that there should be a transmigration and there should be some kind of a horizontal access from one category to the other are destroying the very logic of the SC/ST reservation, and they are the ones who are diluting the reservations for the SC/STs. In fact, the EWS has cemented the affirmative action for the scheduled caste and scheduled tribes particularly, because when the state itself acknowledges that the upper caste, the so-called upper caste, are still economically backward and are in need of affirmative action, the state should acknowledge that SC/STs should get the deserving reservation that they have in their own respective categories. So therefore, when you apply EWS, you are in fact cementing the other forms of affirmative actions for the SCBCs, the socially and educationally backward sections. And in fact, it is complementary. When you create a separate compartment for one section of economically weaker sections, in fact, you are cementing, you are justifying the need for the reservation for other sections. In fact, the economic reservation, economics as the basis for the reservations, does not dilute or affect or impact the social reservations, socially and educational reservations at all. Honorable Justice Maheshwari's judgment, in fact, quotes the chief architect of our constitution, Dr. Ambedkar, who spoke about the need for economic democracy. See, I invite the viewers' attention to paragraph that very specifically quotes Dr. Ambedkar, para 59 on page 98, PDF page 98, which says the chief architect of our constitution, Dr. Ambedkar, on 19/11/48 had stressed in the Constituent Assembly that constitution was committed to the principles of economic democracy as a complement to political democracy. Therefore, see, if you need political democracy, you need to have economic democracy as a sine qua non. In fact, if you exclude the poorer sections among the non-OBCs and non-SC/STs, you are in fact you are imperiling the economic democracy. They will then say, look, I am economically backward. I'm as economically backward as the other SC/STs are, or in fact more economically backward than them. I belong to a weaker section, yet they are getting reservation. So how do we then justify this? You have to say they are socially backward, they get a separate category, they are uplifted in a different mode by the legislature, you too will get your due. And that is the way to create an economic democracy and inclusive democracy, which will create a cementing bond between all sections. Now, those who are opposing the SC/ST reservations will have no logic at all, will have no quarrel at all with the SC/STs. In fact, it was the poorer sections among these sections, the non-SC/ST sections, non-OBC sections, who were at the forefront of opposition towards the reservation. Now they have no logic at all. You have demolished that logic with EWS, and therefore, in fact, it will cement the social democracy, the political democracy, by way of cementing the economic democracy. This is my first thing. I'll be very brief in my next submissions because the other issues fell into oblivion once we address this issue. You see, the other logic is that you are breaching that 50% threshold. Those who say that SC/ST should have been included, SC/ST should be allowed, OBC should be allowed, are the ones who are saying you should not exclude 50%. Now, please decide for yourself, are you in favor of inclusion of SC/STs and OBCs, or are you in favor of, cementing that 50% quota? You are on one side, it is blow hot, blow cold logic. So therefore, with all due respect, I must say, the minority judgment did not deal with that 50% at all. Otherwise, they would have struck down the legislation on the ground of 50%. Because they could not have simultaneously attacked the legislation on the ground that you have not included SC/ST. Now, I am asking myself, if it is your logic that 50% should not be breached, then are you saying that we should eat into the SC/ST quotas? Are you saying we should eat into the OBC quotas? Are we then saying that the 10% reservation should be, in fact, result in 40% reservation for the others or lesser reservation for others? So therefore, this 50% has no logic, and no, either the minority judgment or the majority judgment has not spoken anything about 50%. So therefore, the attack on 50% is completely misplaced. Then, learned senior advocate Mr. Katarki said that Bhim Singh Ji's case has been referred in defense of the judgment, and it is only Justice Krishna Iyer who applied the logic of the principles for, he was the one who dealt with the principles of basic structure in this judgment. In fact, Nagraj is more, is a larger bench judgment. Therefore, Nagraj should have been preferred over Bhim Singh Ji. I beg to differ on this point because, in fact, Bhim Singh Ji is a constitution bench judgment, and Justice Krishna Iyer is on the side of the majority. So it's a settled law that when you analyze a judgment, the separate judgments, a study of separate but concurring judgments, if a judge expresses a view and others don't dissent, it becomes a majority view. I invite reference to a full court judgment of the Andhra Pradesh High Court, which beautifully deals with this. I am quoting this because Justice Honorable M.N. Rao is the one who authored it, and many Supreme Court judgments, in fact, have referred to this. This is Sakinala Harinath versus State of Andhra Pradesh, decided on 26/10/1993. I don't have the citation very readily. Sakinala Harinath versus Andhra Pradesh, in which it is very beautifully explained when a judge, through a separate judgment, comes to the conclusion and others don't dissent the logic, then it becomes part of the entire judgment compendium. So I am reading para 61 of this judgment, which says a study of separate but concurring judgments of majority in Keshavananda shows there is no inconsistency or incongruity in their rationalization. The underlying theme in reasoning is the same, although we discern different shades in our articulation. Even in the case where the different reasons by several judges come to the same conclusion, the decision becomes a precedent, and each judgment contains a ratio, and all rationales can conclusively and separately be treated as precedent. So, Honorable Justice Krishna Iyer's judgment is a precedent. It is a constitutional bench judgment, and it is part of the Bhimji judgment, along with 4 others who are in majority, and he was on the side of the majority. Then finally, my learned friend Nikhil Mehra raised an issue that the judgment does not, the statistical substantiation is lacking. I partly agree with him, but I invite the attention of the readers to Honorable Justice Ravindra Bhatt's judgment, in which there is some light thrown on the statistical aspects. In fact, the judgment goes on to say that the SCSTs and the OBCs form a very considerable section of the poorest of the poor. In fact, para 92, if I am right, says that as an aside, it may also be noted that according to figures available, 45 districts are declared, 64 are declared. See, this deals with the districts. Just allow me a minute. I am coming to the exact portion where the statistical analysis is given in Honorable Justice Ravindra Bhatt's judgment, in which there is a committee report cited on the poverty prevailing in the SCSTs. See, this is undisputed reality that a great majority of scheduled castes and scheduled tribes are the poorest among the poor in India. That is undisputed. And statistically, if you take any committee report, any backward classes commission's report, undisputedly, they form a majority of the SCSTs do form the country's population, a poor population of the country. But then, I must say that cannot allow the transmigration of scheduled caste into the OBC quota. Now, suppose you say that greater proportion of the scheduled castes are poor, and therefore they are almost synonymous with the poverty line, BPL, in our country. Would that justify that you give them a OBC quota as well? Suppose the OBC quota remains unfilled, or can you give SCs a preference over the OBCs in the OBC quota? That can't be done. So because they form a separate class, I'm reading para 92. As an aside, it may be noted that according to the figures available, 45 districts are declared, 64 partially declared, 5th schedule. See, 766 districts in the country, majority of these populations are inhabited by members of scheduled tribes. According to Sinha committee report, this is what I was referring, 48.4% of the scheduled tribes are in the BPL bracket. Now let us assume that 48% of the scheduled tribes are in the BPL bracket. And only suppose, I'm just giving this as a theory, suppose only 25% of the SCs are in the BPL bracket. Say just for theory. Now, can you allow the STs to transmigrate into SC category and say the STs should get preference? Because STs are more poor. They are 48% poor, but SCs are only 30% poor. Say, this can't be done. It is not a poverty analysis logic. See, it is not a poverty alleviation measure at all. The other reservations that we have for SC/STs and OBCs is a social alleviation measure, not an economic measure at all. So therefore, don't mix two concepts. Don't dilute the concept of social and educational backwardness. Please allow that to remain intact. And the best way to allow that to remain intact is carve out a category for economic reservation, which will then not intrude into other categories, and these categories will not see, if at all somebody should have a grievance, it is the others, the non-SC/STs and OBCs, who must then say, you are eating into my quota, who are silent. You are pitting one community against the other by this logic that you are eating into an SC quota. Not at all. It's a separate quota altogether. Even then, how can you say that SC should be allowed into? Then by other logic, then you are allowing these categories also to get into the SC quota and then diluting the whole concept of reservation. Finally, I would say that the logic applied in the judgment by the majority cannot be easily discounted and discarded at all. Whether you say that, you see, even the attack on the basic structure is on the premise that, is on the ground that the judgment does not allow the SC/STs to take the EWS quota. Interestingly, Honorable Justice Ravindra Bhatt says the creamy layer OBCs should have been allowed in the EWS quota. This is even more illogical. See, if you want to allow the creamy layer OBCs into the EWS quota, then why not allow them in the OBC quota as well? Why not? You see, if you want the rich among the SCs to get into some quota, then why not allow them in the very quota? So therefore, you are diluting the logic of the provision of reservation. In fact, I would conclude by saying the social reservation, the concept, the dream of Dr. Ambedkar of economic democracy is what is being realized in this judgment, in this legislation. And therefore, there is large-scale political consensus, large-scale judicial consensus on the issue. And people should not be unnecessarily worried that the social reservations will be done away with. In fact, they will be now cemented, they will be then strengthened by giving a logic that, look, even when the SC/STs can very easily question, when you are giving reservation to the other sections, why not give us the reservation that, look, we are the poorest of the poor. And finally, let us not use this to target a particular community. You are saying there are only 4% of them, 3% of them who are getting 10% quota. Not at all. This is completely misfounded. In fact, this is an enabling provision. The legislature does not say you must compulsorily provide 10%. Not at all. It just says 10% is the outer limit, is the final limit. And therefore, it is only an enabling provision to give reservation. This could be 1%, 2%, 0.5%. Or not at all. Karnataka has not implemented EWS at all. There are many states which may not implement. Therefore, to say that, this will eat into something and, very few people will get 10%. This is completely misfounded. No government will do that, mistake of providing 10% reservation. See, Karnataka has given reservation to almost every caste. Thanks to the Havnur Commission report. I'm concluding in 2 minutes, sir. I'm sorry if I'm taking somebody else's time. Just 2 minutes precisely. Karnataka has given reservation to practically every caste. So also many other states. So therefore, to apply 10% the Karnataka government may not apply 10% because it absolutely makes no sense. So therefore, I conclude by saying EWS judgment by the majority is one of the finest judgments that I have seen, perfectly valid, legal, and logical. Thank you so much for the opportunity provided.
Thank you. We still have question and answer session. That's why we have a regular speaker for Karnataka State Bar Council, Mr. Siddharth Sijoria. I request Mr. Siddharth to say a few words. Take your time, no problem. But question and answer session will be there.
So I want to thank you for inviting me for this session, sir. And briefly, I will explain my points. I agree with the majority verdict, but I do not agree with the increasing the limit beyond 50%. Am I audible, sir?
Yeah.
So if you read the judgment, they have relied on Article 46 to say whether within the definition of weaker section, the socially and educationally backward would always be included or not. And the courts have, in many judgments which have been cited in the judgment, the court have always come up with the point that a weaker section is not defined in the constitution. And weaker section can be defined by the economic capacity or by backwardness as it has been there. So in all the judgments which have been cited in the court, economic criteria can be a basis. So that verdict has been agreed by all the judges, and it has been the basis of the majority opinion. And the second point that has been in this case is whether the exclusion of the SC, OBCs, ST, SC, and SCBC is violation of the basic structure. So I would just, before answering this question, I would come back to what just Mohan sir talked about. Mohan sir said that there is a violation which have been there in the judgment, that the judgment is per incurium because it has not dealt with the test which was laid down in the Nagarajan case. But if we look at how the basic structure cases have been dealt with in India, there is no test which can apply uniformly in India. Even recently in the NJSC case, Justice Lokur in his judgment have said that there is no universal test that you can apply for determining what is basic and when you can suggest that basic structure has been violated. So, and briefly to state that I think that there is no test which is there, because if you look at Justice Maheshwari has applied a different test, Bila Trivedi has applied a different test, and Justice Pardiwala has come up with a different test, and Ravindra Bhatt has come up with a different test. But ultimately, the point that they have discussed is whether the identity of the constitution has been lost or not. And I would say that if we look at how the Colombian court have dealt with the issue when it comes to basic structure interpretation, is that they say that if a new principle has been brought in the constitution, then you have to see whether A, it replaces the old constitutional principle, and B, the new principle that has been brought in, whether it is incompatible with the existing one or the one which has replaced, to the effect that the new principle has completely substituted the old constitution. So that has been how judicial review of constitutional amendment are done in other countries. Specifically, this is in Colombia. So there is no particular test which is there in India. Now, coming back to the facts of this case, I think there was no argument which was led from the petitioner side that how exclusion of the ST, SC, OBC from this gamut of economically backward section of society directly affects the constitution is such a mechanism that the inclusion has done away with the existing principle of prohibition on discrimination on the basis of caste or basis of class. Because as Justice Ravindra Bhatt in his judgment has observed that exclusion has resulted or is violation of basic structure in this case, because the exclusion has been in violation of the constitutional prohibition on discrimination on the basis of caste. But I think that was not the case here, because if we were not judicially reviewing any particular legislation, but this was a higher threshold of judicial review was required in this case, because a constitutional amendment which is passed in exercise of constituent power or derivative constituent power of the parliament was in question. So I think in this case, for the petitioner, what was required before the court to be argued should have been that whether the insertion of 10% or exclusion of the ST-SC community from the 10% quota is a principle that have done away with the existing constitutional principles which require that there should not be any violation of Article 14. There was, and then in addition, I say that there was no particular violation in this particular case, because as we read Justice Pardiwala's verdict, in his verdict, he has discussed how the economic disadvantage leads to itself in itself is a kind of backwardness, social backwardness. It leads to a kind of social backwardness in the sense that India is a country of 1.4 billion people, and if we apply the same, if we look at the Indian constitution structure, and even in the Keshavandan Bharati case, the right have been given to the parliament to even try, and it might commit an error, or it might come up with a solution to an existing problem. So even in India, if we cannot identify that which basic feature has been violated, or an identity of a constitution, existing constitution has been replaced, I think every constitutional amendment would pass the muster of the constitution if it has been brought by procedurally, it has been effected correctly. So if the petitioners in this case had an argument, I think the important argument in this case was with regard to the exceedation of 10% limitation which was there. So I think in my submission that 10%, the ceiling of 50% has become a part of an essential feature by way of conventions. Because if we look from the very beginning, 50% of law, 50% of ceiling has always been there. And Parliament has always been reminded that this 50% can only be violated if there are reasons which are, extraordinary. In this case, as Mr. Nikhil rightly argued, that there was no data. So if we come to discuss that what are the circumstances which can be termed as extraordinary for going beyond 50, I was reading an opinion of Justice Fazal Ali, or I don't remember, where they said supposedly why we cannot cap it mandatorily is because supposedly there is a state where there are 80% of populations which are backward. And if the state comes up with an amendment that 80% seat would be reserved for the backward class belonging to that state, that amendment cannot be violated because as the parliament understand its society, and because in that particular area there are 80% people who belong to the reserved category, then in those circumstances it could pass the constitutional muster. So I feel that in this particular case, going beyond 50% was unconstitutional because it was against the constitutional conventions of making reservation by below 50%, and secondly because there was no data which was given in this case to showcase that this was required. And if you read, I mean, if I might have missed, but I think Justice Bela Trivedi and Justice Pardiwala has also not dealt with this issue. And only Justice Dineshwari in passing has referred that since it's a constitutional amendment, and therefore the intervention of the judiciary can be very little in this case. Therefore, we are allowing this because it does not change the identity of the constitution. But in my submission, it did in a way violated the conventions which have been set by the judicial presidents in this country. So this is my submission on this portion. And then if we and the other point that I wanted to discuss was whether this 50% violation has led to again violation of the constitution, only with respect that if you read, I think why I also feel that this was wrong is because I think they should have done something to not breach that limit, because since 1985 there have been judicial pronouncements to the effect that this reservation should not become a vested right. And all throughout, we are saying that there is a I think the parliament is escaping to come up and discuss this important issue, whether there is a requirement to revamp the system of reservation, because parliament has not relied or even given answer to what has been discussed previously by the courts, that it is not a vested right. The parliament should discuss whether there is a violation of the equality in the real sense, and whether there is a need to discuss. So I feel if this 10% was within 50%, then it would have been an amendment which could have passed the constitutional threshold. But since it has gone beyond 50, it might be, it is correct on the two spheres, that A, on the exclusion, and B, inclusion of the weaker section. But by crossing 50%, I think it has failed as a constitutional amendment. That is my brief submission.
Thank you, Siddharth. Mr. Aditya Sanghi, senior lawyer from the Supreme Court of India. Would you like to comment?
Yes, I would like to say,
Judgment, or
first of all,
like to, yeah,
hopefully
please, in your own way.
hopefully I'm audible.
Yes, sir.
I promise all my seniors that first of all, I'll be very, very brief. I will not breach the time, because already we have discussed the breach of 50% reservation of SC, ST, OBC as defined in Indira Sahani in 1992. So I'll definitely not breach the timing.
Don't worry.
And before I start, I touch the feet of all my learned seniors, because as far as Karnataka is concerned, people in Karnataka might not be knowing me, but I know Karnataka very well, because in 2005, I was selected by Bar Association of India to go to China. At that time, I think the then Advocate General of Karnataka, Mr. Jayaraman, he was the group leader. So
Okay.
that was my first introduction with Karnataka. Then later on, one of the best judges of our High Court, Justice Deepak Verma, he became the Chief Justice, I think, of the Karnataka High Court. Then recently, Honorable Justice Satish Sharma, he became the acting Chief Justice. And now Karnataka has given reciprocal, a very good judge, Honorable Justice Ravi Malimat. He is our Chief Justice. And for the last 1 year, he is one of the best administrators of our High Court. So as far as judgment, which we are discussing for the last about more than 1.5 hours, I'll not go into the postmortem of the judgment, because most of my seniors who have already spoken, at least I think they have done the best possible postmortem. But I would like to say that as far as the minority judgment is concerned, I go with the minority judgment. And according to me, this judgment in long term will be remembered, as is the case of ADM Jabalpur. Why I'm saying, I know that I'm going to another extreme, because ADM Jabalpur was Article 21. But according to me, this judgment has opened already a Pandora's box, because within 72 hours of pronouncement of this judgment, two states, that is Jharkhand as well as Bihar, they have already made the announcements, or they have demanded that the reservation should be allowed by the population ratio. Now, if this thing goes, and after reading the judgment, particularly of Justice Maheshwari and Justice Trivedi, if we go through the majority judgment, it indicates, it doesn't write, but it indicates that later on, population ratio might be the basis for giving the reservations. Now, I beg to submit that as far as the latest judgment on this issue, that is Maratha Reservation 2021 volume 8 SCC page 1, that is Jayashree Patil versus Union of India. The Bombay High Court has upheld that as far as Maratha population is concerned, that is 78%, and therefore the Bombay High Court upheld. But when the matter traveled to the Honorable Supreme Court, the Honorable Supreme Court, relying on 1992 Supreme Court SCC, clearly said it that Indira Sahani remains. So there cannot be any breach under any circumstances of the 50% cap written in Indira Sahani, and which holds till date a very, very good judgment. But unfortunately, once this vertical reservation of 50% is breached by this particular judgment, where the honorable judges, including Justice Maheshwari, is absolutely silent, but it automatically means that now the vertical reservation comes to 60%, 50 SC, ST, OBC, and then 10% is EWS, which means that any day this reservation, after say about first election or second election, I'm not on any political issue, but even the judgment relies, the Indira Sahani judgment says that it's a political gimmick. And we also know it, that in 1990, Mr. VP Singh brought the OBC reservation, and after that, the matter traveled to the Honorable Supreme Court. So we have to be, in reality, understand the nuances of the political actions. So unfortunately, this 10%, what I see, might reach to a level of 15, 20, 25, and the limit is again 50. So what my respectful submission is that as far as reservation is concerned, it cannot, the vertical reservation cannot exceed more than 50% at present. In fact, Justice Pardiwala in this particular judgment has again reiterated the same thing what he has earlier said in another judgment, that reservation is not the solution, reservation must go. And I would like to quote Justice Ravindran in his latest book of Mr. Rajiv Dhawan, a noted lawyer of the Honorable Supreme Court. He has written this book, Reservation, the Parliament Debate 1995 till date. In this particular book, it has been quoted that Justice Ravindran's insightful comment is, when more and more people aspire for backwardness instead of forwardness, the country itself stagnates. So my respectful submission is, it's high time that merit should now be considered as paramount, and ultimately reservation will have to go one fine day, because if these type of reservations are introduced because of political advantages, then ultimately merit will suffer, and the young generation already, I'm the last person to say anything because Bangalore knows it very well, that brain drain is going on in this country for about more than 30 to 40 years. And if this type of vertical reservation is allowed, then definitely a day will come that every meritorious student will run away to X country to Y country. So once merit is not looked after by the reasons which are best known to all of us, but merit is paramount. And therefore, in conclusion, I would like to say that a day will come in our lifetime that a larger bench will be constituted, and the larger bench will affirm the minority view in this particular judgment, because as far as Justice Ravindra Bhatt's judgment, which is in minority, is concerned, that according to me is a best view, because under any circumstances, if you allow 50% to be breached, either by economics or by caste, it will open a Pandora's box, and we have to shut this Pandora's box immediately, or a day will come in this country when we won't be able to withstand the percentage of reservation which we will be perceiving, which I am perceiving. Thank you so much for giving me this audience, and I'm highly obliged for the audience. Thank you so much.
So that's the magnificent assimilation of the best brains, the magnificent conglomeration of the best brains available. Now I open the question and answer session. Kindly unmute yourself and ask the questions to the learned speakers. I have Nitin. Mr. Nitin is here. You can either start the question and answer session, or you can encourage him. Mr. Mohan sir, kindly unmute yourself.
Debate. That's the magnificent assimilation of
I'll unmute all
best brains.
I must
The magnificent conglomeration of the best brains available.
No problem.
Now I open the
am I audible?
question and answer session. Kindly unmute yourself and ask the questions to the learned speakers.
I think, sir, somebody has their YouTube channel on, because of which we can hear that.
Prashant has the YouTube channel on.
Yes. I think no, it's okay. I think now the problem is resolved. Yes, sir. You can go ahead.
Is it me? Can I?
Yes, yes, Nitin. Yes.
Yeah. Sorry if I disturbed the proceedings. I must first congratulate all the speakers. It was very enlightening for me personally. I was particularly impressed with the presentation of Mr. Mehra, which also helped me appreciate the nuances. And the counter by my friend Mr. Sridhar Prabhu was equally enlightening in a way. The dialogic format and the dialectics of it, I think, was impressive. But I do not share. Can you hear me? Hello?
Yes, yes. I all of this.
Mr. Mehra, Mr. Prabhu, the other speakers, can you hear me? Yeah.
Yes, yes, I can hear you. I can hear you.
Yes. What I was a bit confounded by is the categorical certification that my dear friend Mr. Sridhar Prabhu is giving, saying that this is a perfectly justified, valid, logical argument. I fail to understand in what respect. I would say that there is an element of, in fact, I don't even want to enter into the debate of whether reservations on the ground of economic conditions is right or not. Why not can be a comment. I mean, some poverty can be a ground, regardless of caste. Though historically, recent historically, constitutional history has not been very supportive of it. Attempts have been made. Why not attempt that? Is a different terrain altogether. I do not want to enter into it. In my estimation, there was only one major constitutional issue that had to be tackled in this judgment. And may I say this with a little disappointment, that burden has been shirked by this constitutional bench. There was only one burden that we face repeatedly in the matter of reservation, and that is the burden of whether or not to keep the 50% rule as sacrosanct or not. In the face of the much larger benches, for instance, Indira Sahni, 9 judges, clearly holding that 50% rule is sacrosanct. If you are faced with it, as a 5-judge bench, how do you sit over in judgment over that rule which has been given the status of a sacrosanct rule? Isn't there an element of glossing over is my fear. In fact, I am neither speaking pro EWS nor against EWS. I want to make it very clear, because for me, the unresolved issue is the breaching of the 50% rule. To go further, in Karnataka, in practice, we have already violated Devdasan, Indira Sahni, all that. It's already in practice. Now you have given an ex post facto legitimacy to the breaches that have already happened. We need not be worried about 77% in Jharkhand, 69% in Karnataka has already happened. Tamil Nadu has already breached. People are waiting in the wings to breach it. Now the Maratha reservation issue will be revived. No, and everywhere in every state this would happen. I understand that merit needs to have a nuanced definition. I won't say that all reservations that were attempted are per se void or bad, but merit is a reality. There is something called as merit despite and in and through all these debates. We should not give it a go by in such a cavalier fashion, in such a, perhaps a lazy fashion, if not a dishonest fashion. So my comment and my question to Mr. Sridhar Prabhu would be, are you right in saying that this is a perfectly logical and justifiable judgment? What would you say in the light of my rather longish background comment?
Just before that, this question, of course, I'm slightly metamorphosing this question to Mr. Shankar sir. Number one, was Jayashree Patil decided only on the basis that 50% ceiling could not have been breached? Number one, Maratha reservation. And second one is whether 50% is, of course, till this judgment, was a sacrosanct rule which could not have been touched. Was that the rule? That 50% glass ceiling could not be breached under any circumstance? Was that the ratio of the judgment in Indira Sahni and the subsequent judgments? This is the question to Mr. Shankar.
Yeah, this is explained in para 27 at page 41 of the PDF. Nagaraj and Jayashree Patil both are discussed to say that this is contrary to its own view, excluding creamy layer. Ultimately, the concentration is on the creamy layer. See, they are eating into the entire quota. That's the impression we get. And this requires to be further clarified by the, I think in course of time, this will arise again and the matter will be discussed. I think Mr. Mohan Karnataka mentioned that this Jayashree as well as Nagaraj has to be undone and or redone.
No, my question was whether, number one, 50% rule was absolute. The other day we were discussing with Mr. Gautam Bhatia in our group, and this question is it was not as sacrosanct as, as a declaration. That's what when Mr. Nitin said, I was a bit.
Discretion being the reservation being a discretionary issue, there cannot be any limited cap. Or you can say that it's high today, or it has to go down. Ultimately, point is this process of reservation cannot continue forever. one day it has to zero down. If it is tapering down, it's better to say that, well, in court, we are going to redefine this, which I think Rao has mentioned it now. It has to be nuanced differently. I think that will take care of it. The future course of action is to travel back on this issue. We find ourselves whether this population ratio or this ultimately it should not become a political matter. It has to be in reality, and it has to serve the intended purpose of protecting those who are in need of this thing. Creamy layer must be taken out. I think
Mr. Nikhil Mehra was more had more clarity in it that
Yes.
50
So first and foremost, even Indra Sahni does not make it a mandatory absolute cap. So you are asking me the question.
Data was
Right? You asking me the question, does Indra Sahni say under no circumstance can you breach? It does not say so. Indra Sahni says in extraordinary circumstances you can breach. Now, what is extraordinary is a different matter. In the context of this judgment, there is absolute clarity that even that Indra Sahni observation relates to 15.4, 16.4, 15.5, 16.5. It does not apply to 15.6, 16.6. So therefore, when you say states are coming forward with reservation, so let me put it this way. If you add in the EWS, today your new norm is 60%. You cannot breach 60% because you cannot breach 50% for 15.4 and 16. Right? But again, extraordinary circumstances. So the question was asked by Mr. Rai, and he's absolutely correct in observing 50% stands obliterated in Tamil Nadu from the 90s onward. Jayalalitha's government did it. In Karnataka, it stands obliterated as well. But those were regarded as extraordinary circumstances because the population split there is very different. In the north, it would not be possible because the population split there is much more different. You know, you are in Tamil Nadu, you're talking about upper caste in the state in total might be about 18-20% is what I recall as being a general number that was bandied about. Even in a state like Uttar Pradesh, last state like Uttar Pradesh, we're looking at upper caste up to 35-40%. So we are looking at a very different set of numbers here, right? So this is why my problem was the lack of data. If you produce the data, then perhaps the first question you will ask yourself is, have we created a supply side choke because of which we are now coming up with these concepts of reservation to try and solve a problem, which is really about delivery of education. It is not so much about who gets the seat. It is about how many seats you can create.
A small question, direct one, in the light of learned senior Shankar and Nikhil's comments. My question is to Nikhil. There are contrary stances taken by the majority judge, I mean, especially Justice Pardiwala. At one level, he says this extra 10% breaching is fine. I mean, in effect, it is what it is. And he also says that reservations need to go. Now, my question in the light of this contrary stance, at least apparently contradictory stance, is without any motive. It's a plain question. Does it mean that increasing or breaching the 50% rule and bringing in more and more reservation, not keeping 50% as a sacrosanct, is one of the ways in which you can entirely do away with reservation, which is what I aspired for?
Right. So I'll answer this at two levels. First, on Justice Pardiwala's judgment, there is a difference between what in international law we got what is referred to as lex lata and lex ferenda. Lex lata is the law as it stands, right? So one statement he makes is the law as it stands. The other is the law as he aspires for it to be. So there is no contradiction in that sense. He understands that distinction. On your second question, I think you're arriving, if I'm understanding you correctly, please correct me if I'm wrong, is that you will get to a point of so many quotas that quota won't mean anything. Is that what you're saying?
Yes.
But my fear is the opposite, actually. Look, in the context of the fact that any future judgments which are not a review, but a new judgment that is sought on this issue, you're going to have a Chief Justice in place for 2 years who has defined merit very differently from any other judge who has ever defined it so far. So if you read Justice Chandrachud's judgments on merit, he has a much more holistic view of what merit constitutes. And so therefore, he would look at proportional quotas. Now, once you step into the domain of proportional quotas, what you may be correct about is the merit levels within a quota increases, right? Your contest there perhaps increases. And then perhaps the EWS can become a horizontal section rather than a vertical section. right? But in a larger sense, this is only feasible, and those proportion quotas only work without unrest in society if you solve the supply side problem, which is you have enough seats. If you don't have that, then you will have a lot of very frustrated, very capable people watching others go by and go past them and looking at them and saying, you know, I had more than what this person has. So these are really the crux issues. That is why even in this judgment or generally in this law, when we as lawyers say reservation is discretionary, what we imply is it is a purely political sphere question. The politics determines what reservations will be. So today, the politics is determining 15,416 plus 10%. One, I said the sliding doors moment. One side is saying we could now move towards only EWS based. The other side is saying we could move towards proportionate quota. So this is really a threshold. This is like we're on a fork in the road. We don't know where we go. We don't know where the politics goes from here, and we don't know where the law will go.
Mr. Prashant Padmanabhan, you can ask the question.
Yes, sir.
I am
Thank you.
not an advocate. Can I speak?
Only 1 second, Mr. Prashant is raised. He raised the hand first. You can certainly ask the question. Let Mr. Prashant ask the question first.
Thank you, sir. Thank you. It was very enlightening. I don't want to harp on the judgment or dissect it further because all the great speakers have mentioned everything in detail. I wanted to ask something which a common man will ask. Like, if you say that this is not a reservation for the poor, but it is a reservation for the forward caste, because when it was a reservation for Patels in Gujarat, Marathas in Maharashtra, or the Jats in Haryana, that was all quashed by the High Courts and Supreme Court. Now, what cannot be done directly cannot be done indirectly. But the Parliament has passed a new law, which is in fact excluding all the reserved category and created a compartment for the forward caste. And the Supreme Court says, oh, this is fine, because that word is there, economically weaker. If it was for economically weaker, the criteria could not have been 8 lakh and 5 acres. Amartya Sen has said that if you are including this total population of India, only 5% of people have got this much of wealth. And if you include 95% of the population in a category for affirmative action, then that will be defeating the purpose of reservation. That is the statement of Amartya Sen. And now I was wondering why nobody is referring to Dr. Ambedkar's statement, which is mentioned in Justice Ravindra Bhatt's judgment, for saying that 50% quota, because he has referred to 2 things. One is that Tamil Nadu 69% reservation is under challenge after IR Coelho. And then the speech of Dr. Ambedkar on 30th November 1948, and he has given the reference as a footnote. In that, Dr. Ambedkar has stated that there are 2 principles. One is that, can I read out from the Constituent Assembly debates? If honorable members will bear these facts in mind, 3 principles we had to reconcile. They will see that no better formula could be produced than the one that is embodied in subclause 3 of Article 10 of the Constitution. Article 10 at that time is now Article 16. They will find that the view of those who believe and hold that there shall be equality of opportunity has been embodied in subclause 1 of Article 10. It's a generic principle. At the same time, as I said, we had to reconcile this formula with the demand made by certain others, certain communities, that the administration, which has now for historical reasons been controlled by one community or a few communities, that situation should disappear, and that others also must have an opportunity of getting into the public services. Supposing, for instance, we were to concede in full the demand of those communities who have not been so far employed in the public services to the fullest extent, what would really happen is we shall be completely destroying the first proposition upon which we are all agreed, namely that there shall be an equality of opportunity. Let me give an illustration. Supposing, for instance, reservations were made for a community or a collection of
Mr. Prashant, can you frame the question to Mr. The question will be answered by Mr. Sridhar Prabhu. Please frame the question.
Yeah, see, in the Constituent Assembly debates, Ambedkar is giving a situation. Suppose there is a 70% reservation and 30% is only open. Then that will be defeating the first principle that there should be equality of opportunity in employment. Therefore, this should be an exception, and some such qualifying phrases backward. The exception made in favor of reservation will ultimately eat up the rule altogether. Nothing of the rule will remain. This is what is quoted in the judgment of Justice Ravindra. So he has relied on first principles to say that we should not exceed. And he is not relying on any judgment to say that. He has, of course, stated that the other matter is pending before another bench. Therefore, there should not have been an observation by this bench on that.
All right.
So this is my yeah.
See, first of all, Mr. Nitin's question on whether Indira Sahani principles are breached. Kindly see para 92.6 of the judgment, wherein the Indira Sahani is referred to. Honorable Justice Jeevan Reddy's views have been very clearly brought out, and there is a quotation from Honorable Justice Jeevan Reddy's judgment. 810, para 810 of Indira Sahani is quoted. While 50% shall be the rule, it is necessary not to put out the consideration certain extraordinary situations inherent in the great diversity of this country and the people. See, the constitutional imagination for breaching this 50% or carving out another section springs from Indira Sahani itself. Kindly see para 25.4, wherein the economic backwardness has been very clearly acknowledged in Indira Sahani itself. If at all the constitutional imagination or the legislative imagination has sprung from somewhere, it is from the Indira Sahani judgment itself, because the Indira Sahani judgment repeatedly says economic backwardness has to be tackled. The bane of Indian society is the economic backwardness in essence. So therefore, the constitutional imagination transmigrated from the social backwardness to include the economic weaker sections as a whole. A holistic concept was evolved. Then the answer in Indira Sahani is by three judges. One, Honorable Justice Jeevan Reddy, as I said. Then 92.6.1, Justice Pandian is quoted by saying, I fully share the views of Fazal Ali Soncho, holding that no maximum percentage of reservation can be justifiably fixed under 15.4 and 16.4. My answer is, if under 15.4 and 16.4 you can't fix a ceiling of 50%, then can you say when the constitutional imagination goes to 15.6 or 16.6, then too this 50% should be inviolable? See, I must stress and conclude that 50% reservation is not breached as far as the SC/STs and OBCs are concerned. So therefore, it is a new section that is carved out. Just, the constitutional imagination has evolved beyond 15.4, 16.4, etc. and come to 15.6, 16.6. And therefore, it is perfectly justified.
Mr. Sridhar.
Sir, may I speak for 1 minute?
Mr. Sridhar, don't you think, as Mr. Nikhil Mehra said, let us amend the constitution first and then go in search of the eligible candidates and let us find the data. Is that the...
No, if there was political motive, then how can there be a political consensus? How can all the parties have the motive? How can you attribute motive to legislature? How can you say all the parties who have concurred have motive?
Yes,
how can you say the entire parliament has motive, except certain sections? Bar.
Yes.
Everybody has a motive. Then if everybody has a motive, then it's a good motive. We have elected, there's a majority has a motive. The overwhelming majority has a motive, then the motive must be good.
Or the principle is so complex that it accommodates multiple motives.
Mr. Sudeep Kumar Gupta, somebody wanted to ask the question.
Sir, I want to speak for only 1 minute.
Yes.
Thank you. I am not an advocate, but I want to say that all the speakers, they are discussing the limit of 50% as held by Indira Sahani case. Sir, this 50% is a number. in my view, it is only a number, not a law position. The number is not a law to be adhered or to be followed. The limit of reservation can always be increased by government. For example, newer and newer sections may be incorporated like widows, COVID sufferers, extremely dwarf people, extremely long people, tall people, like that. My submission is final. Thank you.
See, 50% rule is because when you go by equality, balancing the equities, you take a balance. Therefore, take the middle part, the middle line is 50%. That is how I think that was the criteria.
No, Basavaraju sir, he is correct on one important point. There is no source of law for 50%. It is purely judgment, it is purely estimate.
True.
An ad hoc arrangement.
No, 50% itself is a misnomer according to him.
Yes.
Okay.
So where do you source it to? There is no constitutional source for 50%.
That's right. So therefore, if there is no sanctity, this is what the worry is there. That if this judgment can take 50% away for one reason, why can't it go away for another reason?
Where did we get this 50%? Somewhere I read, I think Balaji or somewhere, that 50% because that is the middle path. That's the exact dividing line.
Yeah, but that means nothing. Why not 40? Why not 47? Why not 48? I mean, there are better reasons to have percentages, is all we're saying, sir.
May I take 15 seconds more?
Sure.
I am dealing with GST, goods and service tax. There are goods and services. We are taxing those goods and services at a rate ranging from 0 to 170%. These are only numbers. There can be no law to hold that this is the ceiling or this should not be the ceiling. Thanks.
That goes to the very root of the issue, as Mr. Nikhil Mehra also agrees with your statement.
As long as a percentage will not destroy the GST mechanism itself, 170% is fine. But the exception takes over to such an extent that the rule becomes a farce.
Yes.
The idea of reservation itself becomes a farce. Then we are perhaps
that will be the end of reservation that way.
So that is why I asked the question to Mr. Mehra, that is this a good technique? I'm not asking this with any motive. To do away with reservation is a politically hot topic. Whether you are pro it or against it, it is a hot topic. Now, this format or this mechanism of consistently enhancing the percentage of reservation or bringing in a kind of a proportionate quota based on the numbers, etc., a manner in which ultimately you hit that 100% and the necessity for reservation goes, I don't know. I mean, there is wild thinking here, but is that a technique? Is that a political tool, or is it even a
very risky game to play? Very risky game to play.
Yes. That's what I'm wondering. I mean, it's not really, I don't really have an answer, but it seems like it's a good way. So the lex lata and the aspirational, whatever you mentioned, somewhere tends to merge in this manner. The aspiration and the law as it is may find its confluence in this technique, I suppose. I don't know. Just thinking aloud.
So, on behalf of the Karnataka State Bar Council and the Karnataka State Bar Council Law Academy, I thank each one of the panelists for giving the magnificent speech on this weekend, which is already Friday. And we shall come out with another seminar on equally controversial, hot, and inspiring topic in the near future. And on behalf of the Karnataka State Bar Council, I shall thank each one of you for having participated in this wonderful seminar. The entire seminar is already relayed on YouTube. I shall share the link on the WhatsApp group of Daksha Legal and Karnataka State Bar Council. So thank you all. Shubharatri.
Thank you to everyone. Thank you, Learned Senior Basuraj and Learned Senior Shankar, Sridhar, Nikhil Mehra. All of them have contributed.